So this is part of a wider project that I'm looking at the moment, and basically how to teach or reimagine teaching public law. So I'm very much interested in the, I mean, this is a point for us to discuss as a panel later as well. I'm very much interested in the distinction between history and legal history, because very often some of the comments that are received, or I have received, is, you know, we're doing law, not history. And I'm very interested in the kind of definitions and where one ends and one begins. And I'm somewhat skeptical that we can make those kinds of distinctions. And secondly, I'm also interested in the stories or the lived experiences behind the cases we study. I know as lawyers, we ask students or tell students to focus on the law. We don't really want them to recount loads of facts in exams. But some of those, as has just been mentioned by Fred, some of those stories that we miss if we look at cases like Raffles and Witchell House, even Cutter and Powell in contract law with the entire obligations rule. Some of those stories can really help crystallize key issues for me about imperialism and colonialism. And I know Gregson and Gilbert has been mentioned by Fluke Adebisi as well, the Zong case. But even if you kind of dig down a little bit on that, maritime law or English maritime law, at the same time as we were comparing slaves being thrown overboard to horses or cargo being lost, at the same time we were giving ships rights, right? The slave ships had legal personality and the slaves did not. We were giving more rights to the actual vessels themselves. So what I want to look at is, when does an omission become a lie? This was, I can't claim originality here, this was a phrase used by David Olusoga in a public talk about the British slave trade, its abolition, and how slavery made England, Great Britain and the United Kingdom rich. The point Professor Olusoga was making, and the one I agree with, is that omissions, or omitting to tell a story, may at first be a mistake. As any criminal law student will tell you, an omission is not normally enough to give rise to any form of liability. But in certain circumstances, failing to do something is treated in the same way as committing or carrying out the act itself. And the way we do not talk about this country's past, and specifically this country's imperial past and present, I think is more than an omission. So as academics, as teachers, we're storytellers and we have a lot of power in what we do. I also think that everything we do is kind of political in a broad sense. I would question whether it's possible to objectively teach an area of law, because even that is giving an opinion. You are subjectively deciding to teach law in a certain way. And how we tell the stories we do can make a difference. So again, contract law, and I use this actually in constitutional law, the way I teach. Carlisle and the Carbolic Smokeball Company, which I think is introduced to pretty much every contract law student in the first few weeks of study. You get taught the rules of offer and acceptance. But the background, Mrs. Carlisle ended up living until 96, dying in 1942, ironically, of influenza. But she was bringing a case in 1893. We allowed her, the law allowed her to bring a case in 1893, but they didn't allow her to vote. So what I'm trying to look at as well is a form of imminent critique, to use areas outside of public law to try and bring fresh light on key constitutional principles. So by questioning the stories we do tell, we can move beyond the words found in law reports to the historical records and start to question the limitations of the way legal memories have been constructed. So this moves on to national myths, or what I can call a national myth. The stories we tell ourselves about why the UK has an uncodified constitution, which is underpinned with a lack of enumerated constitutional rights and parliamentary sovereignty. Those stories are myths. They are, in terms of this idea, the Whiggish interpretation of history, which has been mentioned already. They are not entirely true. We have reconstructed the past. So Professor Vernon Bogdanor in 2018 was writing about Brexit and the UK's unprotected constitution. And he explained the reason why the UK's constitution is uncodified as follows. And this is quite common. I think this is found in many textbooks. So, quote, countries normally adopt codified constitutions after a break in constitutional continuity, either when a colony achieves independence, the United States in 1776, or to mark a change of regime following defeat in war, as with West Germany in 1949. These breaks in continuity give rise to a constitutional moment and a new beginning. One of the reasons why Britain lacks a codified constitution is that we have never had a constitutional moment. We seem never to have begun as a nation, but to have evolved. We have not since Roman times been a colony, and we have not altered our fundamental regime since the Glorious Revolution in the 17th century. End of quote. So this is not an outlying view. It is selective memory, to be true. The key claim here is there has been an unbroken constitutional continuity for centuries. There has not been an invasion or a defeat in war. And even this, I think, is somewhat selective of British history, to put it mildly. This kind of storytelling also kind of undermines the nature of the United Kingdom. It's certainly true that England hasn't, or at least we can tell ourselves, England hasn't been invaded in a serious manner for centuries. But would the same thing be true of historians of Wales, Scotland and Ireland? That would be it's a very Anglo-centric view of the UK's constitution. Even Ivor Jennings, who's often cited along with Dicey as a key figure in describing why we have an uncodified constitution, made it clear in his Law and the Constitution that, and I quote, the Irish Free State was established in 1921 by mutual agreement, end of quote, which is a very interesting way of summarising a war of independence and an ultimate peace treaty and partition of the country. So the narrative is effectively there's not been a break in constitutional continuity. We have evolved. There's not been revolution. And we see this reflected in the way constitutional law is taught. The case of proclamations 1610 is taught about the royal prerogative. The Habeas Corpus Act 1679 talks about Parliament giving more rights to people who've been arrested. The English Bill of Rights 1689 is taught, often through parliamentary privilege, and the English Act of Settlement 1701 explains why Catholics can't take the throne. But what is lacking in this history is empire, and specifically because in all these dates, this country did have an empire, be it English, later British, or the United Kingdom. The British state, as it was created in 1707, was created as an imperial state. That's one of the reasons why Scotland signed up to the Act of Union. And the British identity has been, from its very beginning, defined by the empire. We teach British legal history because we think it is impossible to understand the modern UK constitution lacking a document, a codified document, without that history. But what we do not teach in the same way is the history of empire, the exploitation and abuse of the slave trade, the dispossession, torture and mass killings in the colonies, and the logic of racial ordering and racial stratification, which people like Adam Elliott Cooper have argued was kind of perfected in the colonies and then brought back to the United Kingdom, and is being carried out today in the way policing and ordering of society is managed. So all of this history about empire does not just inform the modern UK constitution, but is reflected in our constitutional knowledge. English and British history is celebrated. Niall Ferguson, in his book Empire, How Britain Made the Modern World, made it clear that Britain's sacrifice in defeating Hitler in World War II expunged all of empire's sins, whatever they may be. But in her recent book, Professor Caroline Elkins legacy of violence, characterised the British Empire as being administered through legalised lawlessness. Legalised lawlessness. This is a good phrase that I'm going to be using after Christmas to teach this to students. It was through legalised lawlessness that Britain spread the idea of the rule of law. Elkins argues the promulgation of states of emergency and widespread use of emergency powers, including detention without charge or trial, drumhead judicial proceedings, and large-scale executions after unfair trials, was carried out widely in British colonies. Order was brought about through disorder. Most importantly, actions which law students have been taught are unconstitutional or unacceptable in the United Kingdom since the 17th and 18th centuries were not just occurring in the colonies, but formed a central part of how Britain maintained its rule. And this is even more striking, given that English nationality law at the time assumed that if you were born under the dominion of the Crown, you were a British subject. So effectively we have disparate treatments of different forms of British subjects. British colonisers subjugated peoples, constructing them as having failed to socially progress. And this was underpinned by a form of white supremacy. More than this, the history of the empire has been sanitised. In every colony, colonial officials documented everything that was done, including legalised lawlessness. What I draw upon here is the importance of history, not just legal history, but history more generally. From the 1950s to the 1970s, the British government instituted Operation Legacy, when independence was impending for dozens of countries. MI5 and special branch agents vetted all secret documents in the British colonies that could embarrass the British government, including examples of racial and religious bias and abuse of colonial British subjects. In relation to Kenya, and I think given the time, I'll just restrict my comments to Kenya here so as not to overrun. In relation to Kenya, 3.5 tons of files were burned or sunk in oceanic trenches in the Indian Ocean before independence. These documents documented the imprisonment in concentration camps of 1.5 million Kikuyu people, the mass use of executions, well over 1,000 executions, the widespread use of torture, including rape as an instrument of terror, castrations, removal of teeth, and other horrifying situations. And what this legacy has done, literally, Operation Legacy, what this has done is allowed the United Kingdom to deny the truth and reality of what happened. In the Mau Mau litigation, which involved a tort law challenge to abuses of British colonial authorities in the Kenya emergency, which was brought in 2011, in the Matua case, the government only settled after it was disclosed that 1,500 files had been stored in secret at a high security storage facility near Milton Keynes, Hanslope Park. Those files admitted colonial wrongs for Kenyan, what would have been British subjects living in Kenya, that were carried out against the majority black population, specifically the Kikuyu people. Those, effectively for 50 years, the British government had denied anything had ever happened because the documents had been destroyed. By chance, they were discovered. But even then, the British government, after moving to settle the initial claims, succeeded in 2018 for striking out 40,000 claims in relation to this torture on grounds of limitation. Effectively, limitation periods were disclosed or deployed to prevent claims succeeding. This can be compared unfavourably to the use of limitation periods which are waived in a lot of historical sexual abuse cases in tort law that occurred in the United Kingdom 30, 40, 50 years ago. And this is even more galling because the British government admitted that all this happened. But the defence, as was accepted by the Court of Appeal, was that it would be impossible for the United Kingdom government to get a fair trial because these events occurred over 50 years ago, despite the fact the only reason the cases were brought in 2011 and 2018 was because for 50 years no documentation had ever admitted to have existed. So I'll just wrap up now, since I'm aware of the time. What we have here with empire, it underpins the construction and growth of the United Kingdom. The United Kingdom has always been an imperial state. Legal history and history do tend to overlap a huge amount here, because the deliberate destruction of files through Operation Legacy has sanitized officially our view of the empire and has deliberately destroyed imperial abuses, which does not just make it impossible for victims of those abuses to come forward and claim remedies. It also means that the narrative can be pursued that the British Empire was on the whole benevolent and brought a lot of good to the world. And thank you very much